Good evening. My name is Deanna Lockett, and I'm the editor-in-chief of the Alabama Civil Rights and Civil Liberties Law Review. We are delighted that you have joined us for day one of our symposium, The Ever-Evolving Definition of America's History and Tradition. As we examine constitutional rights through a historical framework during this symposium, it is important that we recognize that the right to education itself cannot be analyzed in quite the same way. The Constitution's text and history shows that education is not, in itself, a constitutionally protected right. However, America's students have historically benefited from a federally protected right to be free from discrimination in federally funded public institutions. And it is the Office for Civil Rights at the United States Department of Education that is charged with enforcing that right. Today's discussion will show how through its enforcement, the OCR has played a pivotal role in protecting equal access to education. We are grateful to hear from our speakers today who will share how recent legal and political changes affect both policy and practice. Their perspectives will help us better understand not only where the OCR stands today, but what is at stake for students, educational institutions, and the promise of equal educational access moving forward. Now I will turn this discussion over to Alabama Law Professor JD Hsin, who will introduce our speakers.
Well, welcome everybody. Thanks to Deanna and to the whole journal for hosting this, I think, truly special event on education and executive power. Today's conversation is about the federal agency really at the center of it all, which is the U.S. Department of Education's Office for Civil Rights. In one incarnation or another, OCR has been the federal government's primary enforcer of civil rights in education for over 50 years. In that role, as you may know, OCR oversees the more than 13,000 school systems and nearly 6,000 institutions of higher education, including our own, that receive federal funding. If your school takes any kind of federal education money, as just about all of them do, OCR is the federal agency you probably worry about the most. And we're incredibly lucky today to be joined by the two people who most recently led that very important office, former Assistant Secretaries Catherine Lhamon and Ken Marcus. Catherine Lhamon is the inaugural Executive Director of the Edley Center on Law and Democracy at Berkeley Law. Until January 20th of last year, she was the Assistant Secretary for Civil Rights at OCR. And that was actually Catherine's second tour of duty in that role. She's also led OCR as its Assistant Secretary during President Obama's administration from 2013 through 2017. She's also held a wide variety of other roles in public service from January through October 2021. Catherine served as the Deputy Assistant to the President for Racial Justice and Equity. From December 2016 until January 2021, she chaired the U.S. Commission on Civil Rights, while also serving for 2 years in California Governor Gavin Newsom's cabinet as Legal Affairs Secretary. In addition to her government service, Lhamon has also litigated civil rights cases at the ACLU's Foundation of Southern California, the National Center for Youth Law, and Public Counsel Law Center. Kenneth Marcus is the founder, chairman, and CEO of the Louis D. Brandeis Center for Human Rights Under Law. Ken served as Assistant Secretary for Civil Rights at OCR from 2018 to 2020. Before that, he served as staff director at the U.S. Commission on Civil Rights and General Deputy Assistant Secretary of Housing and Urban Development, of Fair Housing and Equal Opportunity. In academia, Ken served in a number of roles. He served as the professorial lecturer in law at George Washington University and formerly held the Lilly and Nathan Ackerman Chair in Equality and Justice in America at the City University of New York's Bernard and Baruch College. He currently also serves as a Board of Visitor member at George Mason University. So, you both held one of the most consequential, prestigious posts in education policy, certainly, even the federal government. I wonder, before we get into the specifics today, maybe Catherine, we can just start off talking a little bit about what surprised you about this role that you took on. I mean, were there things about the job that you didn't expect?
Thanks, JD, and thanks, Ken. It's great to be here at University of Alabama. It's great to see all of you, and I'm so encouraged to see this interest among law students and others in education civil rights. So thanks for that uptick in my day, just to be with you. And then to talk specifically to the question of what surprised me at the Office for Civil Rights, one, I was not at all surprised about how amazing it is and what an incredible pleasure it was to work with the hundreds of staff who do the work in that office and to work with school communities around the country to ensure that our civil rights guarantees were the experience of students at the desktop. But there were, I think, some pretty key surprises for me, and chief among them was the quantum of misunderstanding and lack of understanding about the application of federal civil rights law in schools that I saw, that when I was there both times in the Obama and the Biden administrations. It was frankly shocking to me. I'm a lifelong civil rights lawyer. I think about civil rights all the time, so I sort of thought everybody else did too. It turns out that's not so. But it's also, even if it's not your job to think about civil rights all the time, it's not the thing that gets you up in the morning, it is our school's job to ensure that no person experiences discrimination on a protected basis. And so that means that it's our school educators' job to know those rules, and it's certainly our school lawyers' job to know those rules. And I was astounded when I came to the federal government by the many people in those roles who didn't know and weren't complying. And I guess good news, bad news, wasn't necessarily that they had intended to discriminate, it was that they didn't know. So that's the good news part, but the bad news part is that they were discriminating. and the failure to heed decades-old requirements from Congress as interpreted in the courts to ensure student civil rights has caused incredible damage to the fabric of our society and also to students trying to learn in schools. And I was shocked, and also it lit a fire under me for how much more we needed to do and how best to use the tools, which I'm happy to talk more about.
Good to see you again, JD. Truly an honor to be here, and a pleasure to be with Catherine. This is the first event we've done together. We are in an unusual position in that we both served in essentially the same position. We both served twice in different administrations, and we alternated. I don't know, that certainly never happened otherwise in the Department of Education. I don't know at a sub-cabinet level that it's ever happened in any agency. And I don't know how you feel about it, but I think maybe it's okay that we're giving the Republic a rest now and letting letting other folks have a turn. Yeah. So it's a pleasure to be with you. One of the surprises was that there was, I would say, more areas of agreement than I had realized among administrations and between different people who are looking at a large percentage of the issues that the Office for Civil Rights deals with. For the most part, prior to arriving at OCR, I was aware of OCR, the U.S. Department of Education's Office for Civil Rights, from newspaper accounts, magazines, so on and so forth, which is to say, from public accounts of the most newsworthy and often controversial matters. And OCR does have its share of controversial matters. So at the time, it was looking at issues from affirmative action to Title IX in athletics, and so on and so forth, where there were clear, well-defined differences. But it was interesting to me to see the amount of agreement. So maybe it's not surprising that I don't disagree with what Catherine said about hers. I would also say, and without wanting to suggest any disrespect for the other departments I've worked at, that comparatively speaking, I was impressed with the professional caliber of so many of my colleagues, both career and politically appointed. And I even think that in some areas that improved from a fairly high level over the years, and I found that to be a refreshing surprise.
Well, I wonder if we could talk a bit first then about OCR and what OCR does. I think just to set the scene for folks in the audience who might not know OCR as well as we do, OCR doesn't write legislation. OCR is not a court. It's an enforcement arm of a funding agency. So OCR has other tools at its disposal. You've got enforcement tools like investigating complaints, conducting compliance reviews, and then on the policy side, you have tools like writing regulations and guidance. So, I wonder, Ken, maybe we can turn to you first for this question. So when you walked into that office on the first day as assistant secretary, you've got all of these tools at your disposal. What are you reaching for first, and why, and how do you think about using those tools to advance the office's work?
So my own experience in the 2 times that I was there is that it always felt that I was joining in medias res. It was always in the middle of things, right? It might have been my day one, but it didn't feel like day one. There were other people who joined the administration on inauguration day. If you didn't join then, if you joined months later, for example, if you had to be Senate confirmed, then there was a long period when people were coming up with plans and developing things, and then you're in there. Even if you came in on inauguration day, there had been the landing teams, there had been the campaign, so all of this. During my second tour, when I came on board, I remember certainly the first public-facing thing that I ended up doing was contrary to advice I'd been given by a cabinet member. It was, so she said to me, so that the sort of the top of the stack, the issue that was ripe for decision, and that was just ready, I didn't choose it, but it was ready, was an affirmative action policy. And the advice I was given is, don't start with that. I start with that and it will define you. I started, the first thing I did, she said, was something controversial. It wasn't something that I necessarily thought this is how I want to be defined, but it ended up sticking with me. She said, don't do that one first. Choose something else that's going to be just broadly popular, and then sort of build up. And that was probably very wise. But my view it was...
You didn't take the advice.
I did not take the advice. I did not take the advice. My view was, I'm not here to burnish my reputation by choosing things that are popular. And if I wait, I'm going to do fewer things. You know, the most you're going to be in a position like that is 4 to 8 years. But usually it's going to be a lot shorter than that. On average, it's closer to 2 years, and that was my stint. It's more of a sprint than a marathon. I figured I want to do the right thing by my standards on as many of the things as I can do, taking them as I come. So I just took the first one that was ready for me, I signed it, I did it, and then I went on to the next. I don't recommend that necessarily, but that's how I handled it.
Yeah, it's very entertaining. Thank you about those starts. I certainly agree with your characterization of, the political staff having come up with plans, et cetera. And the career staff do also. And the Office for Civil Rights at the time that I was there, I think the time that you were there also, had roughly 600 people in it. So there's 600 people who are doing things around the country and working to enforce civil rights. And so, my approach in coming was to find out what they were doing and hear what their plans were, and to make sure that I could get out of the way to help allow that good work to proceed. And I'll just tell you, we're in Alabama, so I'm going to tell you a story about Alabama that happens to be a case resolution that was really early in my tenure, my first time in 2013 when I came to the office. There's a school district in Alabama that had 4 high schools, one of which had 90% black students, and the other 3 of which had very small percentages of black students. So there's, race segregation taking place in the district in the first place. But the identifiably black high school, we learned in investigation, had never offered a single advanced placement course or an international baccalaureate course or any of the traditionally recognized high-rigor courses until we started investigating, ever. And our case team asked the principal why he wasn't offering those courses, because the black students, the other high schools were offering them, the full panoply of those courses, and black students in the other high schools were taking and succeeding in them. So what was it about this high school that meant that the kids there couldn't access those courses? And that principal said to our case team that these kids need remedial education. So good news is that principal's not the principal there anymore, and also, right, shocking, and also our case team said that has to change. We have to make sure that all kids have equal access to education opportunity in this district and in this high school. And instead of saying start offering those courses next year, which of course they did say, they also said go back to kindergarten and find out what it takes to make sure that the kids know and the educators in this district know that these courses are for everyone and that we are going to support all kids in realizing their dreams. That case resolution's extraordinary. It's exactly what the Office for Civil Rights should be doing, and I had absolutely nothing to do with it. I read about it when the agreement was signed because our career staff had done it, they'd investigated it, and it was ready. And so weeks into my tenure in the office, that's the place that I knew I had come into, and I thought, these people are amazing, and this opportunity to get to do this work is amazing, and I am going to find a way to support more of that. So what I did was to work with them and to find ways to make sure that we pulled all the levers. And JD, you asked, which of the levers do you pull first? Everybody who knows me knows I don't pull any lever first. We do all of them all the time at the same time. So we went for all of it. But it's because there's work of that type. That was 2013. There's work of that type that we needed to be doing to make sure that all of our kids had equal access. And we had 600 people ready and willing and wanting to charge at that charge. And I was not going to get in their way.
Well, I wonder if we could stay on the enforcement side, Catherine.
Yeah.
'Cause I'm wondering about this, because you come into the office, as you said, and you're inheriting a lot of cases that are ongoing. I mean, a backlog of many cases. It was at times hundreds. It's now more like thousands of cases.
Yeah.
You have a finite staff. You have an agenda, though, that the administration wants to advance, partly through enforcement. So how are you going to balance, and how did you balance the sort of responsive enforcement, which is just dealing with the cases like you're saying that you have, that are in the backlog, and cases are already in the pipeline, with how do you balance that with a more proactive policy, like setting the agenda and advancing the agenda, maybe even sending a message?
Well, I think there's a lot to do with the reaction, because the reaction reflects what people are worried about and what they're bringing to the office. And so it's important to take those cases seriously. Every case that comes into the Office for Civil Rights reflects somebody's deepest hurts and their belief that they have been wronged in a way that our laws guarantee they will not be. So it's really important to take that seriously. And every one of the laws that the office enforces is incredibly important, and every one of the students in schools is incredibly important. So making sure that the office can get through that docket is the charge of the office. I also don't think there's anything that's purely reactionary or purely proactive. I mean, the office has proactive jurisdiction and is charged to open compliance reviews, and so it's important to do that. I think of policy guidance generation as also quite reactive. When you're doing it right, you're doing it responsive to the questions that school communities have, and the kinds of things that our case teams in the Office for Civil Rights saw coming up over and over and over again in their case investigations. And so recognize a need that school communities need to know more information. So to me, I felt like it was important to plumb what we were seeing, what were kinds of repeat issues, so that we could make sure that we were giving guidance to answer that question, so it wasn't a surprise to the regulated community. And also, when we weren't seeing issues come in, and I know, Ken and I both experienced this as leaders of the office, there were particular kinds of categories of cases where the problem takes place in schools, and we were not seeing a lot of complaints come in. And so then, I think it's important to issue guidance to make sure people know you can come to us about that. That's something that we will do and we will respond to. I also thought it was really important to let people know what we were doing. That we didn't want to be the trees falling in the forest that people don't hear. We wanted people to know we were seeing these kinds of issues, and this is how the law applies to the facts in this particular case. And so other school communities could see it and think, do we have that problem? Should we address it? And how do we deal with that too? So I thought it was really important to be loud about what we were doing. I guess the last thing I'll say, thinking about that in response to your first question on that, JD, is the president has priorities, of course. My experience is that the priority for the Office for Civil Rights is to do its job and to enforce the law. And so there wasn't certainly neither time I came in did any president say to me, you should do this one thing and not the others. It was do all the things and make sure that you're getting as much done and doing as much justice as you can all the time. And certainly nobody needs to tell me that twice, so I was happy to work on all those issues. But I certainly never felt like there was something that was important to the president or important to someone at the White House, and so we should do that and not the rest. It was that we really needed to do all of it.
Yeah, there really is that juggling where you feel you have to do all of it. So I first entered OCR as a litigator. That had been my background when I first started in 2002 at OCR. And so I really leaned into enforcement rather than policy. It was what came natural. And I thought that that's where the rubber met the road. My view when I first started was that people can put anything on policy, that's on paper. But the real question is, what are you requiring institutions to do? If they violate the rules, what are you going to require change? And so for me, enforcement was sort of the be-all and end-all, sort of at the beginning. Later on, I came to a different view, which is that oftentimes policy statements can have an enormous impact far beyond the number of institutions that actually get involved in OCR enforcement matters. At the beginning, since my background had been primarily litigation, I thought that a contribution that I would have would be to improve the enforcement process. So I really worked hard on that, improving the speed, efficiency, et cetera, and so forth, the legal caliber of the work that was done, which I don't think had been at nearly the level that it's been in recent years, and so forth. And I remember I gave a talk in the San Francisco office about the things that I was doing to improve the process. And I was asked the question, okay, but what is your policy priority? And at that point, it almost seemed like the wrong question, because every student was my priority, and I didn't want to give any impression that any area was less important than others. There had been some impression of a prior administration that neither of us served in, that maybe it had a lot of focus on a couple of issues, but if it wasn't you, they didn't care. And my thought was, at the time, disability was the highest in number, but it had not been a priority. But the special needs kids in public schools should get every bit as much attention as anything else. But I quickly realized that while that's partly true, the fact is that the staff needed to hear from their leader about at least one issue in a way that made tangible the passion, the emotion that the leader cared. And you can't just do that in abstract general terms. And so I started talking about an issue. And the issue that became my focus during that administration was the plight of certain both racial and ethnic minorities in special education. So that had become a particular focus, and I thought it was resonant for its time because we had a president who spoke a lot about reading and research-based reading, and there was a connection between students who were misidentified for special education because they didn't have appropriate reading instruction. And the problem wasn't that they had a disability, it's that they weren't given an opportunity to learn. So I talked about, ironically, even though that was what I ended up speaking about a whole lot and giving a lot of my focus, it was a work that I did on a different topic altogether, addressing anti-Semitism and discrimination against ethno-religious groups that became by far so much more the focus of attention that people afterwards thought that was my issue. But I did think that it was important to have both a policy agenda, an enforcement focus, and at least one issue that you could use to galvanize the attention and the passions of the staff.
Well, I wonder then, I think it'd be remiss if I didn't ask about probably the biggest stick in OCR's bundle, which is the way we enforce anything, which is the threat of pulling federal financial assistance or termination authority. You know, OCR has that termination authority under all of the laws that it enforces. But, you know, historically, it's done it very rarely, certainly in the last quarter century. I don't think it's done it at all, I mean, until recently, at least tried. And that's what we've seen in the last few months. I think we've seen maybe a different approach being taken to the termination authority. So maybe I'll ask this of you first, Ken. First, why is that? You have this ultimate stick that you can use, but OCR, at least in the last 30 years, has just not used it. Why is that?
So there are lots of different reasons. Some of them have to do with statutory and regulatory requirements before the money can be frozen. That is a big thing. You have to go through all these different hurdles, and you have to give lots of different opportunities for the recipient to resolve the situation, and that takes a whole lot of time and gives a whole lot of opportunities to resolve it. I think that's number one, is the legal impediments. I also found that there are political challenges and also cultural challenges. I'll say culturally, I found that there were several opportunities. So to me, it was a problem. It was a problem that schools didn't fear OCR as much as I personally thought they should. and that, oh, I'm gonna get in trouble. And that meant that we had somewhat less leverage than I would have liked in a lot of different negotiations. And I believe that if we at least once, certainly if we took money away from anybody, but even if we came very close to taking money away, it could change the negotiations over lots and lots of different situations. But it was structurally difficult, and the career staff, they were taught in a particular way. So getting folks to really stand their ground at the end of the day, I found that difficult. Maybe you didn't find that difficult, but I found that difficult. And then politically, it's very hard. I don't know if I'm jumping. So so there was one occasion where I said no to a school system. And it was huge. I mean, this is a difficult topic, so forgive me, OCR deals with difficult topics. It was both sexual harassment and sexual assault of high school kids in Chicago. And this was something that had gotten some media attention, and I was in a position where I was asked to sign a certification for charter schools. You remember that? That they magnet school, thank you. For magnet schools, that they were in compliance with civil rights laws. To me, that was a crazy requirement. How am I going to certify that they're in compliance with all the civil rights laws, right? Even if I were the superintendent, they're obviously not. So, but I certainly didn't feel that I could sign it, knowing about all of these problems that had even been in some of the papers and that my staff was telling me about. And I said, I don't see any basis on which I can certify that the Chicago city schools are compliant with civil rights when there's all of this going on with sexual assault and harassment. So I said, I'm not signing it. I can't sign it. Well, that was huge. And the members of Congress get involved, including members of Congress who had demanded that the department do something. But then when we do something, it's like, oh, no, not that. Right. And then everybody wants to know, now, wait a minute, you mean you're going to take money away from these magnet schools? What do you have against magnet schools, right? And they're like, don't you know that the magnet schools are doing this and doing that and doing the other thing, right? So there's always socially worthy projects, otherwise Congress wouldn't have. So all of a sudden there's this massive pressure, and the department, people who work at the Department of Education don't work there so that they can take money away from schools, right? All of the pressure is to give the money to the schools. So when you're standing up and saying no, you get immense pressure from Congress, from media, the staff, the department. And so at the end of the day, they did some things, we did some things, and we ended up getting to the point where we resolved it and signed it. But it really was an instructive lesson that when you say no to the funds, even for a period of time, the pressure becomes immense.
Yeah, and I just to say that the Magnet Schools Assistance Program statutory scheme is, as Ken described, that the Assistant Secretary for Civil Rights has to sign off certification that the recipient of the funds, that the district will comply with civil rights laws prospectively. And it is kind of an astonishing thing to sign off on because you don't superintend that school community. On the other hand, wow, what a power to help make sure that they do comply. And I said no lots of times on that, to get school districts to change. When we were using the investigations to evaluate whether they were in compliance, and if they weren't, they couldn't have funds. But that's super straightforward. The fund withholding under Title VI, Section 504, and Title IX requires, as Ken mentioned, too, a very stringent set of procedures first that include reporting to Congress, and making a finding, giving the school community a chance to come into compliance, reporting to Congress that you will withhold federal funds, giving Congress time to review it. And in the intervening time, there's time for court review and to litigate the question whether the law has actually been violated. And at every stage, the school community can come into compliance and keep their funds, after lengthy opportunities for administrative and litigation review first. So it's in the statutory scheme, very complicated, very hard to withhold federal funds. And I think that's fine if slow, but Congress needs to change that if it's going to change it. I want to just fight the hypothetical. I did use the fund withholding mechanism a bunch, and I was very loud about my willingness to withhold federal funds from anybody who hurt a kid in school. And so that meant that we saw more compliance, because I think school communities believed me and were really clear that I was totally fine with doing it. And here are ways I know that communicating that mattered. And I too was a litigator when coming, so I agree with you that the schools needed to believe that the stick worked to come into compliance with it. But we'd had no endpoint for negotiations written into our complaint processing manual when I came in to the office in 2013. And we had some prominently known universities who are ostensibly in negotiations with OCR for 5 years, where nobody was coming to the table, there were no negotiations taking place. They had findings of violations communicated to them, and we were not talking about what to do to fix it, because they just weren't fixing it. And I thought, well, that has to end, right? So, I changed our complaint processing manual to say that there would be a 90-day period. When OCR communicates finding of a violation to a school, that school has 90 days to correct the violation to OCR's satisfaction and enter into a resolution agreement. And if it doesn't, OCR will initiate fund termination. That's what will happen. And it was very unsettling. That was a big change for the way that we would do our work, and there were school communities who were pleased to test it, and I was pleased to send an impasse letter, and that we would begin the fund termination, and within those 10 days, the school communities came into compliance. So that's a major change, and it means that the fund termination tool is incredibly effective, even when you don't actually have to hold the funds. But I will say here, what I said when I led the office, is that I would be happy to withhold the federal funds from anybody who violates the law, period. I mean, that just is. And knowing that, seeing that that was so, incentivized substantial compliance. JD, Professor Hsin, I apologize.
Oh, no, please.
when you say that this administration now is using that fund withholding tool differently, that's not true. They are acting in an unlawful way. They're not using the fund termination tool as written in statute. They are acting like mob bosses, and they are withholding federal funds first without making a finding of a violation, without following any of the statutorily required processes, and then seeing if anybody will hold them to account. Multiple courts have reminded them that that's unlawful. They are losing persistently on that question, because it's not a close call about what is and is not lawful. And the degree to which it's a successful tool is the degree to which we exceed as a community in our own law violations. So it's time for us to stop. The schools need to say, that's not the process, and I'm prepared to litigate that, to challenge what you're doing. But it's not an administration that is more aggressively using the tool that Congress gave it. It is an administration that is making up out of whole cloth a set of extra legal requirements that facially violate our law. And I think that's quite dangerous. So I think we need to call it what it is.
And on that point, just follow up on that. Maybe Ken,
I want to address that.
you want to address
I
that?
don't
Go
know.
ahead.
Okay, sure. So I'm not in this administration. I don't write in, and
right,
I'm not focused on this issue. But there is a complicated question that's a little different than the way you posed it, but maybe you see it differently, and that's the following. The administration has certainly said that we are going to use not just our grants, but our contract authority with the full degree of discretion that is provided for government contracting, which is rather sweeping and extraordinary. For anyone who is accustomed to the long, cumbersome process that we've worked in, and the fact that it never leads to a real permanent cessation of funds, it's extraordinary to be reminded that for the government's massive contracts, those funds can often be halted, at least for a period of time, but certainly halted even for convenience and without anywhere near the sort of cumbersome process. And so that's raised a question. If the government can, for convenience or virtually anything, just halt a contract, but Congress, in a very specific statute, Title VI, has given a process when it's discrimination based on race, color, or national origin in a federally assisted program. Can the federal government say, we have a massive problem right now, a crisis involving anti-Semitism and other related ills, and we are going to exercise our authority, our discretionary authority under contracts to hold massive funds? Or do they have to use the cumbersome process? And I think the argument in favor of it is, it can't be the case that Congress has actually made it harder for the federal government to protect the rights of racial minorities than to do something just for convenience. It can't be the case that the Civil Rights Act of 1964, which we think of as creating landmark civil rights, in fact, was reducing the rights of ethnic and racial minorities by saying, if you, the federal government, have massive amounts of contract money, you can freeze it in a very quick, easy, expedited way, unless there's a Title VI violation, in which case you have to go through lots and lots and lots of hoops. So I think that part of what the administration is doing, and it is only a part of it, I think that there are some remarkable things personally that it's doing, including the involvement of Health and Human Services, including the significant involvement of Equal Employment Opportunity Commission, and certainly GSA. So I think it's, to me, it's at least more complicated.
Yeah, so we'll just stay on this. I think I disagree in every respect, just to say on that, it's unclear that the cessation or termination of funds based on contract convenience is actually something that the federal government has the authority to do, but we'll bracket that as its own separate new question. But it is unquestionably the case that the bipartisan Congress that enacted the 1964 Civil Rights Act, and then the later statutes that involve the same statutory scheme for fund withholding, contemplated exactly that question, and contemplated exactly whether the federal government could tell the states what to do based on the federal government's preference. And there was a lot of hand-wringing about the wisdom of having the federal government set that baseline, and fear about specifically what we live now, which is that there might be an autocratic president who would try to impose the preference of the president on the nation extra outside the process for what our laws provide and what we assign to the federal government as distinct from state and local governments. The ultimate consensus was there's a floor below which we shouldn't fall as a country. There's a set of equality aspirations that we have that we need to enshrine in law, and that we will say, yes, there are times when the federal government will tell school communities, local communities, this is how we will behave, because the alternative is so awful to imagine that we would continue to live as a country, what we were seeing with fire hoses in the streets and governors standing in front of schoolhouse doors, blocking people's entry, and lunch counters at which people were being hurt and excluded. The that we can't continue as a country that way. And so there will be circumstances, but we want to be very, very careful about how we determine that that is a violation and that there's a process for testing whether that determination is correct, and that there's a process to allow those communities to come into compliance. It's incredibly cumbersome. I chafe against the length of time, and I really understand that, and I think there's ways to make that faster, but one should go to Congress for that. But the ultimate view that we want to make sure that when the federal government makes a determination there's discrimination, that's a fair process, and that there's an opportunity to test it, was where our Congress has landed, and that has been unchanged. The current administration, when it is saying we are concerned about, sometimes it's anti-Semitism, sometimes it's transgender students' rights at school, pick your topic, we're concerned about that, and so we're going to withhold federal funds, means that they are, on the one hand, explicitly invoking the civil rights laws, and then on the other hand saying this is merely a contract dispute. And every court that has looked at that has seen through that. Every court that has looked at that has said no, and has said, pick one. If you want to call it a contract dispute, we can litigate the question of the contract dispute, and there's a place for that, and that's how we'll do it. But if you're saying that you're doing this because you're invoking the federal civil rights laws, that we have a 6-decade consensus about how we will operate them, then you will do it consistent with those laws. And that's not because we're saying that those laws are less important. It's because we're saying it is so important to who we are as a country that we decide what an equality principle is, and that we have a shared consensus about that, and we have a process for determining whether that's fair or not. And I think if we walk away from that, we walk into the abyss, and that's where we are right now.
Ken, if I could maybe follow up with you about this discussion, to take a broader look at it, is there a concern here, or do you have a concern about maybe either turnabout, if the administration is going to change hands in some way, but if it were to change party in 2028, are we worried about turnabout or a ratcheting effect from what's going on right now? Because I think it's probably fair to say that OCR in the last few months has certainly been at least threatening its use of termination authority a little bit more assertively than it has, in whatever form. I mean, are you worried that another OCR 4 years from now, could either turn around and use the same powers that Catherine's describing and that you've described, or ratchet it up and start using even more aggressive uses of its power, termination authority? Does that concern you all? Should we be concerned about that?
So first of all, I'll agree that we disagree and that we disagree on everything, although I have to say, respectfully.
As described, yes.
Although I have to say that there are some of the bigger issues on which I'm not fully decided, but I don't think that you've characterized them, certainly in the way I would, because I think that there is a fair question about whether the administration has identified a contract dispute for which they can use contract powers. And while it is true that plaintiffs have done well so far, it's often true that plaintiffs will do well in the lower courts because they get to choose their lower courts, and then we see how it happens when they move up. This administration has moved powerfully to address a crisis. And because they've moved powerfully, using an approach that's unlike what had been done before, your question is a fair question. If this administration had not moved in an extraordinary way, then a different kind of question would be appropriate. If this administration had followed the same old, followed the Title VI process according to the way that I had developed some of the policies back in 2004, and did some of the early work on it from 2004 on. If this administration had continued to do that in the same way that I would respectfully describe as somewhat plodding under the best of circumstances and under any administration, slow, and not always entirely up to the moment, we would be asking a different question. I think that there would be huge calls for how can we live with a statutory structure that just doesn't seem to be up for the moment. And many members of Congress were asking me that question prior to this administration. So that's the choice. either a slow plodding process where the question is, how do we live with ourselves in failing to meet the moment, or a radical change? Now, how you feel about that depends in part on whether you think the radical change is nevertheless consistent with the law or whether it isn't. Do I wonder how it could be used in different administrations and on different topics? Yes, I think I do. To me, what this administration has done needs to be viewed in the context of a kind of an emergency or crisis that it dealt with. I'm not sure what the other emergency or crisis would be, but I certainly think it is appropriate in extraordinary and unprecedented times to use unprecedented and extraordinary measures.
So-
Can I just ask, so Catherine, is there any way to put the genie back in this bottle if there were a change in administration?
Well, I hope so, but yeah, for so many reasons, right? And I am prepared to work on that. But I do want to disagree again, in substance and in practice. The crisis is not new and is horrifying. So I am with you that we need to make sure that all of our kids every day are safe at school, and that hate does not proliferate in schools and in our communities, and it's the job of the federal government to address that head on. I do not think that transparently taking money away as a gambling tool changes hearts and minds in schools, communities, and changes the experience of students who are hurt and unable to access education, and changes our larger national community in the degree to which we respect each other and treat each other with dignity and support. And what I know is that the spade work of changing community cultures so that people are accepted and welcomed and can learn is worthwhile and does not follow from taking money away and then walking away. It does follow from working with communities, changing the ways that schools respond. And we've done that. We've done that on this issue specifically. We did that in the work that we were doing before October 7th and the work that we were doing after October 7th. I'm just going to give you one example that I think I'm enormously proud of and that I just was pleased to read about rather than having gone and asked for this answer. But before October 7th, the Office for Civil Rights entered into a resolution agreement with the University of Vermont after investigating anti-Semitic conduct at University of Vermont. And what we saw was very, very, very concerning about the university's non-response to repeat allegations of harassment that students were experiencing and incidents of violence, very dangerous incidents for students on the campus, to which the campus was just not responding, consistent with Title VI based on what we could see, and not visibly a safe place for the students who were bringing their concerns to the administration. And that we entered into a resolution agreement that required change practices, that required policy change, training, work with the school about how it should respond and how it should be communicating its responsiveness to the school community. And the Hillel director wrote in the Times of Israel shortly after, months after the resolution agreement, and about the implementation, that students were safe and that students felt incidents still occurred and students felt like they could come forward and they could work with the university. And that's the most gratifying response I will ever have to the work that I do. And it didn't require taking money away. It did require working with the school community to understand what the law is, change the way that they practiced, and to communicate to their kids that their kids were safe and that their kids were respected, and this is who it will be. So I think that we have to operate like it's a crisis. I don't think that we should operate in a way that doesn't work and that is transparently not designed to protect all of our people. And just to say again, the laws that the Office for Civil Rights enforces, and I have enormous respect for you in the way that you developed the recognition of Title VI to ensure its application to the full range of national origin and shared ancestry, and that in the guidance that you oversaw when you were there, the guidance always referred to anti-Semitic conduct and also anti-Arab anti-Palestinian, the full range of protections on that basis for all of us. And that's the job of the Office for Civil Rights. The resolution agreements that we secured in the Biden administration on this topic focused on those issues because we unearthed the same kinds of concerns for students of all national origins in schools. So at Brown University, when there's a new resolution agreement with Brown in the Trump administration that it secured on pain of fund withholding, when we investigated Brown, we saw anti-Palestinian harassment that was as concerning as the anti-Semitic harassment. We documented it in our resolution letter. We documented it as among the terms of a resolution agreement. The Trump administration rescinded that agreement, entered into a new agreement with Brown that is focused only on anti-Semitic conduct, ignoring the documentation of a need to address all of their kids all of the time at the school. And when we are transparent that we are for some and not for all, that we are picking and choosing whom among us our law respects, we are doing harm. And I don't think that's good for our communities. I don't think that we can look ourselves in the mirror as lawyers for that kind of work, and I don't think that is something that any one of us should want to see replicated.
May I?
Yeah, please.
So, first of all, we found something we could agree on.
Yes.
Right, so.
You're welcome.
No, I didn't just mean your compliments, but I thank you for that as well. No, I mean your characterization of the University of Vermont case, which
Yes,
I agree
yes,
is as
yes,
important
yes,
as you described
yes,
it,
yes.
which is why I'm glad that we filed it, right? This was
yes.
a Louis D. Brandeis Center
Yeah,
case.
yeah.
And I do think that it was as important as you described it. The Hillel director whom you mentioned said that his campus had, as a result of the OCR investigation, gone from worst to first.
Yes.
Because prior to our filing, it had been described as the worst campus in the country in one survey, whether true or false. And then afterwards, it significantly increased. This was, I thought, one of the most important resolution agreements to date, if not the most important one. I think it was the first, though, of that presidential term, and
In higher ed.
in higher ed,
Yeah.
that's right, and perhaps the only one at the time the presidential strategy came out. So it was, no?
No, but in higher ed. So, yeah.
In higher ed,
Yeah.
in higher ed. So it was important, it was one, it was useful, and to your credit, you didn't just issue it, you spoke about it. And you spoke about it in conferences. I wasn't
Right.
there, but I heard about it.
Right.
And you used the experience as a galvanizing force. This was prior to October 7.
Right.
With October 7, the world changed. With October 7, 2023, and I'll say on October 6, we were tired.
Right.
On October 6, we had seen the prior year was by far the worst year for campus anti-Semitism that we'd seen
Right.
in my career. It was absolutely horrendous. Those people who said they discovered the issue on October 8, I wonder what they were doing
Right,
until
right,
then.
right.
For the year ended October 6, it was horrendous. But with October 7, what we saw was not just the atrocities abroad, but on one campus after another across the country, an acceleration of incidents that was at least tenfold in volume from our reporting to us. Anything we'd seen in the historic year ended October 6th. So what we saw then was a crisis moment. You said this isn't new. In a sense, this is an ancient problem. And in a sense,
Right.
it's certainly a problem that I'd been working on for
Right.
2 decades before. And yet at the same time, what we had in the period following October 7, and arguably to date, is a transformation of the problem at a level that has hit certainly members of the Jewish community who had been oblivious to it has transformed it. So that's why I think that it was, as members of your administration acknowledged, certainly in conversation, an extraordinary, unprecedented situation requiring unprecedented and extraordinary situation. I didn't come up with that term. It was one of your distinguished colleagues. So for that, I think that it is appropriate to ask the question, we're facing something that's, yes, ancient, but also new, a level of it, a crisis of it that we haven't seen before. And it's not enough just to have a case every couple years or so, or even 10 of them. What we need here is a whole of government approach.
Yeah.
A massive change, and the sort that the government hadn't previously been built for. And that's why I think it was so important, and it is so important, not just to use the old processes, but to be much more powerful and more innovative.
Yeah, just to say, we resolved 5 times as many anti-Semitism and shared ancestry investigations in the Biden administration as the prior Trump administration had resolved. And so it wasn't 1 or 10, or a handful. We leaned in hard, and we worked hard, and we were prepared to do over and over what we had done at University of Vermont. And we did that in K-12 schools, and we did that in higher ed, and we did it because it was necessary. We already had in place the national strategy to combat anti-Semitism that was a whole-of-government approach, that was working on the ways to be aggressive about it. And we've lived in the history of Office for Civil Rights, the recent history of Office for Civil Rights and presidential administrations, the ways that we navigate a sea change of that type, where we are responding to a crisis. There's no part of me that would ever say that we don't need to be concerned about the incredible rise in reported hate incidents in schools that we need to be addressing. And I had been a litigator in school issues before, 17 years before coming to government. And I think I'm a pretty good litigator. And I've been working on, for example, race discipline issues before coming to government. And we were making very little difference in a national sense on that topic until President Obama started talking about it and using the White House bully pulpit to say this has to end. And until Attorney General Eric Holder started talking about it and Secretary Arne Duncan started talking about it. And suddenly we started to see massive change in the issue of race discrimination in school discipline because we were using other levers that didn't violate Title VI in the way that we did it, but we saw dramatic change. Likewise, the whole of the Obama administration resolved something like 18 or 19 sexual violence investigations in colleges and universities in all of the 8 years. And nonetheless, we saw a massive sea change in federal, local understanding of whether rape is acceptable under Title IX in schools and whether schools have an obligation to address that form of sex discrimination. So a handful of significant resolutions with the president and the vice president and the secretary of education talking about them as issues that we need to address and creating, we had a whole of government strategy on campus sexual assault in the Obama administration. And we live differently now. Does the issue still exist? Yes. Is every school year an opportunity to visit harm on somebody? Yes. And I hate that, and it's why I'm a civil rights lawyer. But are we very differently understanding the obligations that had, up until that point, been in place for more than 4 decades in schools, and that now we live and expect differently for our kids when they're in school? Yes. So I think we can make massive change within the confines of law, and if we think our law is insufficient, we have a mechanism to change that, and we ought to use that also.
Well, on that, do you feel like, since you're talking about responding to a crisis, do you think OCR has the right tools or enough tools to respond to crises like you're describing the crisis of anti-Semitism on campus? Another one that comes to mind that we all lived through, I started with you there, 2020, Ken, on this, was COVID. I mean, did you feel like when you responded to COVID that you had the kinds of tools that were needed to meet that moment when millions of kids with disabilities lost services, English learners lost access to services, low-income students just disappeared from the rolls? I mean, Ken, you were there first during COVID when it hit in March of 2020. I mean, did you feel like you were just watching a civil rights crisis unfold in front of you and you couldn't meet it, or did you think OCR had the tools? And maybe this is a problem for Congress?
It certainly felt like a crisis, but it was a health crisis that had an education crisis together in it, in the civil rights, including especially disability, within all of that. So, I mean, it was certainly a massive health and social phenomenon that was headed our way I did not feel we had sufficient tools or power to deal with, in part because so many of the decisions had to be made at the school district level, at the state level, and at the federal level. In the early days, I would say the civil rights issues that I had in mind were first, very early on, I had the concern based on internet chatter that there would be within the schools harassment of Asian students. I was told to wait up a little bit until there was anecdotal data, and then we issued guidance on that. I then had concerns, other sorts of concerns as schools were closed about disability issues. And some of those were non-compliance, but some of it, I mean, it was just a tragedy. I mean, there were just so many kids who lost service for such a period of time, and, you know, there's no fully remedying for that. So, I'm not sure that even in the best of circumstances, even if, you know, we controlled Congress, that there's a way of legislating a perfect solution. But yes, I did feel that it was a massive health, education, and civil rights cluster of challenges for different groups of people, for which we made different kinds of progress, but not nearly sufficient.
I give you enormous credit for the guidance that you issued on that topic. And I was a governor's lawyer in California at the time, and so I was certainly worried about schools. I was worried about what was unprecedented in law on every topic related to COVID. And I was grateful to see that you spoke specifically to the issue. And I, to your question, JD, about whether Professor Hsin, about whether we had the tools in the office. I think we had the tools, and we didn't have the people. We didn't have enough people to be able to address it as we should. But I was pleased to also issue guidance to speak to the specific issues. Kenny and I are both parents, and we have kids in schools, and so I know what the school districts my children attended when I was the governor's lawyer, and then when I was the chief civil rights enforcer in the nation's schools, and what they told me about what my kids were not entitled to because of COVID. And I'll tell you, I wouldn't have said that to me. But I also thought if they will say that to me, then what are they saying to the other moms about their kids? And so we need to be there for them. We had begun administrative enforcement against a state that would not come into compliance statewide on COVID, so I know we had the tool to be able to address it, and I said I was prepared to use it, and I did. We also secured resolution agreements with school districts where we secured more than 1 million hours of compensatory services for students because those school districts had violated those kids' rights. And we saw more than $5.5 million reimbursed from the district to families because those families had outlaid their own funds to provide service for their kids when their districts weren't doing it for them. So yeah, I think we had the tools to do it, but we didn't have the people to respond timely. And you all know Professor Hsin as an extraordinary professor, and I'm sure that he is. I'll tell you, he was also an extraordinary warrior on this topic. It was my pleasure to work with you and to work with our teams as you took on the hardest cases and answering the questions that were first in the nation about should there be a mask requirement, should there not be a mask requirement, how can you best serve kids today to make sure that they're okay. Did somebody have a reason to have an exception? Did they didn't? These were all first time ever questions to be answered. And the kids and the families and the districts and the communities that were confronting them needed help. And we had among the best minds in the country to answer it. So it was really, really great to be here. So yes, we had the tools.
That was
He's
you
right
and the
here.
enforcement team. Well, I'd be remiss before we run out of time if I don't bring up the topic, I think, elephant in our room. So let's talk about DEI just for a moment, if we might. There are several recent executive orders that have directed agencies to eliminate DEI in federally funded institutions. The terms become a flashpoint. It means different things to different people. So, Catherine, how should we think about DEI and OCR's role in policing that? Does it have a role? And maybe more broadly, what do you think about OCR using its funding leverage to sort of shape institutional cultures one way or another? Is that appropriate?
Well, it's I mean, that's the easy question. The design, the congressional design for the office is for the office to use its funding lever to shape school communities. I mean, what then President Kennedy said about the law when it was in contemplation was that it would enshrine the simple justice that no federal funds should be used to discriminate. And if that's a simple justice, then they should be used, and they should be used aggressively. So I love that. The executive orders, I'm going to law school. I'm just going to say the thing that we all should know. Executive orders don't change the law. The executive order directs executive agencies and how a president wants those agencies to operate, and Godspeed on that. But the law is the law. The law has not changed on this topic. And when the president and presidential appointees denigrate something that they refuse to define as DEI, and just to be clear, the Secretary of Education at her confirmation hearing was asked, would it be unlawful to do X, Y, or Z? Because that would be unlawful DEI. She said, I don't know. I'm going to have to go research that. If the person who would become the Secretary of Education could not answer that question, then how could we expect anybody else to answer it either? If we don't define it, then we can't say that we shouldn't expect it to be done. But putting aside this sort of profligate, ridiculous exercise of complaining about an activity that we won't say what it is, the actual obligation in our school communities continues to be to offer equal educational opportunity. And when we say that there's some harm that's being visited based on national origin, or race, or sex, or disability, or color in a school, and we want to see it corrected, what that is a DEI activity. And we ought to be celebrating that that happens. And there are times when that is the required way to make sure that a school community is safe and that everybody can learn in the equal access that we have guaranteed. So I am unbelievably frustrated that we have this straw man that we can't attack because we don't know exactly what it is, but we are communicating that something that the United States Supreme Court, the last time it looked at the question, explicitly said is still permissible, and saying that it's not. That is making up from whole cloth what somebody wishes the law were, rather than going through the process to try to create agreement and to write something into law. And that is actually the constitutional scheme that we have long lived with.
I respectfully disagree. So I would say, yes, we should move beyond DEI, but I would also say that generally speaking, those people who support DEI mean something different by the term than those who oppose it. I recall being at a hearing when members of Congress all spoke on the issue of DEI, but it became very clear that they were speaking of two very different things. Those who supported it spoke in favor of a system that they described as having been in place for decades, by which they obviously meant a cluster of statutes, regulations, and other approaches to ensuring equal employment, equal opportunity in different spheres, and perhaps more beyond it. Those who opposed it were not speaking about that, but rather about different forms of either preferential treatment or alternatively ethnic or racial stereotypes. The executive orders on DEI do have some definitions, and they define the term as discriminatory equity ideology. That is to say, they are referring to something that's a little bit different than the DEI that its exponents support. To the extent that one follows the actual terms of some of these orders or state legislation, I think we're actually talking about discrimination, racial and ethnic stereotype, and the like. So that it's time to move beyond. It might be that we agree on something here, which is whether we support something called DEI or whether we oppose something called DEI, we should be moving away from discrimination and towards equal opportunity.
Yeah, no question about that. I will just say that the executive orders actually don't define what DEI is, and the guidance that the Department of Education has released has been enjoined nationwide because it was nonsense and not consistent with what the United States Supreme Court has actually said. And the Department of Justice issued guidance that also includes explicit notions of something that is unlawful that the United States Supreme Court has said is lawful. So the thing that we are fighting about is what is illegally, I 100% agree with you that discrimination is wrong, and so when discrimination occurs, it shouldn't take place, fine. But when we won't say what it might be, and we will say something that leans in that area might be unlawful, and so you probably shouldn't do it, then what we're doing is fear-mongering. We're not actually helping school communities to know what the law is, to figure out how to comply, and to make sure that all of their students are safe. And that's fundamentally the job of the federal government, to help people live our national aspirations and our federal guarantees.
Well, in the interest of time, I just have one more question. I think I'd be remiss if I didn't ask you about OCR's future. As you know, government downsizing is on the table in a way that it just, I don't think, has been before. You know, and that's obviously hit home for OCR. You know, in under a year, OCR, if you haven't heard the news, OCR has gone from 12 regional offices to 5. And after laying off hundreds of staff last year, I think the department has, under litigation, reversed course, but I think it said publicly that it still plans to continue with the reductions in force. And of course, there's talk now, in the media at least, of OCR being moved elsewhere in the government. So maybe, Ken, I'll just ask this of you, this last question. So I think those of us who are in education, I think students and parents and educators and faculty want to know, well, what should we be thinking about this as we watch OCR seemingly shrink? I mean, is this something we should be worried about? Should we just get used to an OCR that's a lot leaner than what we've seen? Or should maybe we think OCR should be doing something else now that it's apparently changing its scope and size?
So I don't think anyone thinks that we should just maintain the status quo. The administration is making clear that their plan is not to keep a shrunken OCR, but rather to close the Department of Education and to replace it in various ways. Some parts of the Department of Education should go to other agencies like the Treasury Department. Other work currently done by the Department of Education should be done by the states. Presumably, OCR should be done in some place other than the Education Department if the Education Department is closed, and most of the plans provide for it to go to the Department of Justice, which I think is the most plausible place for it. Now, that would ultimately require an act of Congress, and whether there will or won't be such an act is a question. In the event that we do have an act of Congress that would move OCR, I think the devil will be in the details. It may be that a new civil rights function dealing with education will be as strong or stronger than what we had before, or it might not be. There will be a big question if there is congressional legislation. What is this function? Who handles it? And how can we make sure that we have the best of what OCR has been doing, but without any of the weaknesses or challenges? If there is an upside to it, I think it would be integration with the Department of Justice's litigating functions. One of the improvements that I have always wanted to see is a smoother continuity between the administrative process at the Education Department and the litigation process at Justice. And that hasn't been developed because there have not been cases that go that far. It is not inconceivable to imagine a situation in which an OCR function integrated with the Department of Justice would actually have more clout by increasing the number of cases that are brought to enforcement with greater deterrent effect. Whether that happens or not, I don't know. But again, it is not inconceivable that we're moving into a direction where we could have improvements in the broad ability of the federal government to deter noncompliance with civil rights laws.
I certainly agree with the value of improvements in the ability of the federal government to deter noncompliance. I think it's important to recognize that the Department of Justice litigation function means that it's picking and choosing which are the best fact scenarios to bring in the right courts, to push the law in a particular direction, and thinking through those litigation questions. That's important and hugely consequential and very different from the question whether every mother's child in school deserves equal education every day. And that's the job of the Office for Civil Rights. There's an incredibly beautiful function of having a federal government available to answer the question to everyone about whether their rights have been violated, whether you have an attorney or not, whether you understand the law or not, whether you're particularly careful in the way that you formulate your question to the federal government, you can get an answer. And even if your facts are not the best facts to present that question, and even if you're not in the jurisdiction that some litigator is most interested to press that question. It's fundamentally a respect for you as a learner every day. And losing that is what would happen if you move to a multi-decade litigation-focused entity, which is the Department of Justice. I so respect their work. I so respect, well, not now, but in prior times, I have so respected the work of the Department of Justice. And I think that one can get back to a time when it's a respectable agency again. And its function is totally different from the beautiful administrative enforcement function of the Office for Civil Rights. And that office should be housed within an agency that is focused on education. Congress found in 1979, when it created the Department of Education, that the dispersion of efforts across government related to education did not serve students. That has not changed. I know from leading the Office for Civil Rights how valuable it was to be working with civil rights experts, thinking about what the law is and how it should apply in school, in the context of other people who were thinking about just how schools function and what do school communities need and how do they work, so that when we were tailoring solutions and remedies for civil rights violations, we were doing it aware of how a school works and whether a particular solution would or wouldn't work in that community. You do that because you're in a department where everybody is thinking about school and education every day.
I think that's our time as my question. Do we want to do a question period or just recess and do? We want to open up for some brief questions, maybe a few minutes. Maybe questions for our panel?
I have so many comments of just like how I relate to the things that you are saying. I used to work for the state, and being a government official, trying to help colleges and universities, tell you their problem, because they don't, they don't want to be audited, they don't want to be caught doing the wrong thing, and so a lot of times it was just like going out to them and offering help, and not being like this regulatory thing, but being a partner that can help create a network. We were able to do some wonderful things. So I wanted to say that first. I appreciated that. But my question is more, I listened to a podcast called 5 to 4 about how much the Supreme Court sucks. And it goes through like the importance of the laws and how they were written, and dissects each opinion of how they got it wrong, or who brought the case. They do a pretty decent way of showing the history of how the case got there, and then what the ultimate opinion was. Is there anything like that, or literature, any kind of medium that you lean on or enjoy to like relight that fire as you go through these cases and go through your careers?
Is there a place where we find the distillation of the cases and what they say? You mean, is it, or where we're following? I mean, that's the Supreme Court. I just, we're in a law school. I'm super nerdy. I really like reading cases, so I do, and I am looking for the cases that are. I think about civil rights all the time. I've already said, so I'm looking for the cases that touch those issues, but I read those.
The question was about finding cases or finding inspiration?
Finding inspiration. What do you find
I don't find that from the
fun?
court.
So, I guess I find it from our intake function. It's from the people who are calling in, writing in, talking to the lawyers. I should say, so when I say ours, I mean the Louis D. Brandeis Center for Human Rights Under Law, which is a civil rights organization that I founded and ran, and we hear every day from students and families, but also employees and labor union members and just all sorts of people, and it's sometimes horrifying what they're going through. And I have to say that the people who spend more time than I do, just hour after hour talking with folks, emotionally taxing and difficult. It's mentally challenging, especially during crisis situations. But we don't have to go to periodicals. We just have to answer the phone, and unfortunately, inspiration is there.
Yeah, yeah. So I was missing the looking for inspiration part, and I think the Supreme Court is not the place for that right now. So, but I do think that, I run a democracy center now, and so I am seeing lots of people who are standing for democracy and standing for their communities and finding the ways that they use that in law, finding the ways that they use law to function as a civic community that works, and that's incredibly inspiring to me. So I'm grateful to be able to read that in our news now.
There's some constitutional law scholars, I'm thinking specifically of Justin Driver, who talk about public schools specifically being incubators or laboratories for either the expansion or contraction of civil rights. In your experience working in both OCR and litigating civil rights outside the school context, do you find that to be a true comparison or a true theory?
I do, not always for great reasons, right? I mean, they're incubators for civil rights change, often because they are places that are not providing the equality guarantees that we promise. And also, and the better reasons, there are lots of school communities around the country that are finding success in unexpected places and that are supporting the full scope of the learners in them. And, that's really exciting. But I think we have not innovated as we should have as a country on the ways to make sure that we see and we support every kid in every school. And there's plenty of room for growth on that now.
So I think that schools more broadly can be incubators of civil rights opportunities, not limited to public schools, but also including private schools and homeschooling. I think that when educational freedom is available, which can include different kinds of public schools, including charter schools, but also other options as well, people can have more opportunities to figure out how they want to convey values to their children, the sorts of lifestyles they want to have and to convey. They might have religious convictions that they want to add, or non-religious or secular. So I think that as educational freedom initiatives spread around the country, to me, what's exciting about this sort of incubation is in the broad variety of different kinds of educational contexts in which people are able to provide for their children.
First, I'd like to thank y'all both for coming and speaking. I especially enjoyed the kind of disagreement, the agreement to disagree. I think that's something that should happen more and does not happen enough today. My question is for Miss Lhamon?
Layman.
Lhamon.
Ms., yes.
So I'm kind of trying to understand your opinion on the biggest stick in the bundle as we discussed, because originally it was like in your discussions, that's a power to threaten, that's the power to discuss with the schools. But then when it came to application later on, your opinion on, or at least what I understood, was that it wasn't helping the kids at the time with this new kind of action by this presidency. And so my question is just, how do you view that stick in terms of action of that stick? Is it more the process that does the work, or is it the stick itself?
I think it's the stick itself, and I'm glad to clarify that I don't think this administration is using the stick. And so that's what I object to. I think that it is making up out of whole cloth something that is not the stick that is written in statute. But I think that the stick is incredibly powerful. And so here are examples. When I, with the Office for Civil Rights, communicated a violation to a school community, and the school community said, we're not going to do the things that you think we need to do to correct the violation, I said, it's time to initiate fund termination. And then the school communities every time said, okay, fine, we will do it. That's incredibly powerful. It's so much faster than when I was a litigator before, and it's so much faster than driving change another way. You only get there if you're willing to use it, if you're willing to say, okay, we're going to start that process, which I was, and I did repeatedly, and so then we got school communities to come into compliance. Had they not, we would have walked through the process in statute to withhold their federal funds, and I would have been delighted to do it. But we wouldn't have made up a new process. We wouldn't have withheld the funds first and said, then maybe I'll investigate later to figure out if there's an actual violation, which is the life that we live right now. And that's what I object to. But it's not at all, I have no objection to fund withholding as a process for securing relief for school communities once you have determined that the violation exists. And I just want to be really concrete about why it matters to do that investigation first rather than the fund withholding first. Just to give you an example, we investigated and entered into a resolution agreement related to Drexel University. The complaint that came into us was that there had been arson committed on a student's door because that student was Jewish. And I was aghast reading that. That was in the news. That must have been terrifying. It was terrifying for the school community. We investigated. That's not what happened. What actually happened was that there was fire at a door. The markers that had been reported in the news as indicating that there was a student inside who was Jewish, and there was a student who lived on the other side of that door who was Jewish, but the markers on the door had been Halloween stickers. So it absolutely wasn't that particular incident had been what happened. But in our investigation, we saw other things that supported a need for resolution at that school community. I'm glad we investigated that. I thought that was incredibly important. And you don't take the facts as alleged as a given without investigating to figure out, does the school need change or does it not?
May I? So I have a different way of thinking about it. So it's my sense that people often have strong views about a number of the issues that OCR deals with. And OCR deals with race and sex and disability and all sorts of different things. And oftentimes, people will think that some of the issues that OCR deals with are not just legitimate issues, but are profoundly concerning issues. And for those people who think those issues are really bad, really problematic issues, they will often think that OCR is too weak on it, not sufficiently ineffectual. And they will look at resolution agreements and say, meh, maybe fairly, maybe, but that's often an observation. But then there will be other issues where they think, well, that's just not legitimate. That's heavy-handed government. That's not even a civil rights issue. That's something else. That's political, it's ideological, whatever it is. And on those, they'll say, oh my God, OCR is overwhelmingly powerful, they're heavy-handed, they're crushing, they're coercive, so on and so forth. You must hear that a lot, because I hear it a lot, and I hear both things. And I think that oftentimes people have those same opposed views of OCR, depending on what the issue is. And my sense is that those conflicting views are not necessarily wrong, any of them. That is to say, there are some respects in which OCR and administrative civil rights enforcement generally is just agonizingly weak in its ability to make real change. Just so frustrating in the amount of time it takes, the resources, the inability to and in others, it has the potential to be overly heavy-handed and strong. Now, maybe you say, well, that's a sign of a system that works. Or maybe you say it's a system that sort of fails in different ways. But I just have to find from my own observation that there are just too many different ways in which the federal government is either failing by being too weak or being too strong where it shouldn't be. And that just happens simultaneously, and it is simply a part of the system, a part of the process.
I mean, sure, I think we all have criticisms of any government all the time, and I and all of us among us, but fundamentally, I think what you're describing is the limits of law, right? That it is enormously unsatisfying that our strongest tool in the law is to say, yes, you were hurt, and we will put in a system to make sure that somebody is not hurt going forward. You don't get your life back before you were discriminated against. That doesn't happen. And that's not something that we can gain from law. We can gain from law the value of having somebody stand for you and say, I see you, and your life experience isn't what we have guaranteed. And I have lived my entire life in the light of that promise and what it means. And just to share an example for why that matters. My mother was 10 years old in the year the Brown versus Board of Education was decided, attending racially segregated schools in Richmond, Virginia. And she didn't stop attending racially segregated schools ever thereafter. The decision didn't change the circumstance of her education. And growing up in that time, she still couldn't try on a hat in a department store. She sat in the back of the bus as required. She drank from the colored water fountains. That was her experience. It never stopped being her experience. And she heard the highest court in the land say that her experience was unlawful and that she had a right to live differently. And she raised me with those expectations, and she raised me with that promise without having lived it, without having seen it, and without having a basis really to think that her two babies would experience something different, but she had the hope. And she had the hope because the United States Supreme Court said it. And I don't think it's enough. I don't think that incremental change is enough. I don't think it's okay that the battle for equality is always Sisyphean. And I know that my life experience has been better than hers. And I know that my two children's life experience will be better than mine. And I know that that's because I and the 600 people in the Office for Civil Rights, and many among us around the country, and you sitting in this audience, are fighting for it, and are going to keep fighting for it. And that is worth it, and that gives me hope.
Well, on that note, I want to, inspiring note for OCR, thank Deanna and the Journal again for hosting this really fascinating, I think very spirited discussion. And because I don't think I'm ever going to have this chance again, we're on a live stream right now. And I think we're being joined by, I think, hundreds, as I understand, possibly, of our former OCR colleagues. And I just want to take the moderator's privilege to thank them, to thank the hundreds, now even thousands of current and former OCR staff who gave and have given so much of their professional lives, really of themselves, to making sure that America's schools and campuses are a better, more equal place. And I just wish more of America could see what we saw, at least what I saw, which is how hard they work day in and day out across administrations over decades to make sure that every child and student in this country has an equal opportunity at an education. So if you're watching tonight, OCR, our OCR family,
Love letter to you, yes.
thank you for your service, and thank you all for joining us, and especially, of course, we want to thank my former Assistant Secretaries, Catherine Lhamon and Ken Marcus. Thank you so much.